Okay, thank you very much, Warren, for a very clear and reflective path through the whole justice reform journey. So, a lot to think about. We have a bit of time for questions. Trevor, I think you had your hand up first, and then John.
Thanks, Jen. Thanks, Warren. Very, very interesting. Very quick question. Do they have issues with delays in the European jurisdictions? Or to what extent do they have issues with delays?
Yes, they do. And actually, I mean, there are lots of very bad features of European jurisdictions. The worst feature, in our view, that is those of us who went, which is me and Vet since the Elizabeth Don, was that none of them have a guilty plea system. Everything has to go to trial because you don't trust defendants to be able to work out whether they did it or not. They might be telling lies when they do it, so you need to have every case determined by independent evidence. So surprisingly, although the majority of our cases are dealt with by guilty plea, none of theirs are. They may be resolved in the event there is an admission by a truncated set of evidence, but nevertheless it's always a trial. So as a result, in terms of average length of time, it's undoubtedly longer because all has to get to trial. And I wouldn't necessarily either say that in their systems the length of time between first, if you like, arrest and trial was necessarily shorter because their paper-based system is often in itself quite inefficient. But of course, there's no court appearances between one and the other. So it's quite difficult to make a realistic comparison. Our sense was when we asked them actually how long, was that by comparison with our not guilty plea cases, it was about the same length of time, but without all of the court appearance tune we have. So I think there would be a way of actually, getting the best of both systems actually in a sense.
Yes, I think it'd be interesting if you took out all the court appearances except those that are absolutely essential at the end of it. You'd have lots of blank pages in the Dominion Post and on Radio New Zealand. How would they fill at that time? With nothing to report. But that's just an aside. I two questions really. Are these kinds of delays and so on and so forth that you find in New Zealand replicated in Australia and England with similar systems? Or is it just that New Zealand is more acute in that respect for some reason? And secondly, I might be wrong in this, but haven't Scotland come up with some sort of administrative procedure to cut out delays so that the whole business has to be, they're given a date by which everything has to be determined, and if it's not resolved by that date then the case just collapses?
I think taking the last bit first, my recollection is that the way you've expressed it is too broad. That is, there is an expectation that it will be done by a particular date. Yeah. And if it's not, then the court reviews it and determines what then happens. And the court can direct that then it not proceed because it's an abusive process, but it simply triggers a review process. Scotland has also, like a number of other jurisdictions, I was going to say like common law jurisdictions, have introduced also case management systems. So they've got a requirement that the parties, file what the evidence is going to be and what the issues are going to be and so on. In relation to sort of how we compare with other jurisdictions, even although the UK and Australia have introduced case management processes, because they've actually not really introduced any processes to back it up, that is, there are no consequences for failing to comply, they're actually case management processes that are honoured in the breach rather than the observance a great deal of the time. Australia, it varies from one jurisdiction to another, but generally, I think, is even worse than we are. And the Australian criminal court process pre-trial is simply antiquarian. It's astonishing in all sorts of ways, and it's much more formal and much more alienating than ours. So I wouldn't by any means say that we are worse than those that we often closely compare ourselves with. Two wrongs don't make a right.
Can I just ask a question? What would be your preferred alternative model with regard to sexual violence cases?
Very good question. Well, first of all, and most importantly, and if you have a look at our discussion paper, there's a whole section on this. The most important thing I think would be to develop that. That is the major problem that we actually have with sex offence cases are not with the cases that do get to court, but the cases that don't get to court. Where the victim gets no closure, where the offender is not held accountable in any way, and where the system, in one way or another, ends up simply further increasing the harm and increasing the risk. And you can't solve that problem by changing the formal system. And that's because sex offences by their very nature are not offences that you can often resolve in a formal context that requires proof beyond reasonable doubt. So we can't. But of course, every time it goes before the system, and we've taken an increasing number of cases before the system, and there's an acquittal, the victim ends up thinking that she's not being believed, the offender's not held to account in any way, and it's a process that's enormously damaging. And I actually think, notwithstanding the fact that, I've been a party to a lot of the reforms in this area, that one of the adverse consequences of what we've done is that the acquittal rate in terms of the cases that get to court has gone up over the years. We're convicting fewer people. What we need to do is develop something out of court that actually enables you to address what happens without the consequences of a conviction, but with actually outcomes that can hold the offender accountable. So we actually, in our discussion paper, did actually spell out in quite some detail what we thought that would look like. We did that in close consultation with the sexual violence sector, and probably of all the parts of the discussion paper, it was the ones that we really committed ourselves to what we think the reform ought to be. And if you think about it, one of the reasons for that is often because, particularly in cases where there's no disagreement that a sexual encounter occurred, often the problem is just that the parties have a totally different perspective about what happens. The defendant might, either in retrospect or actually at the time, genuinely but totally unreasonably believe there is consent. Or might actually just have never been brought up to use, if I can use the expression, to use sexual manners. The victim, from her perspective, absolutely believes that she did not consent. We don't have any mechanism for having those differing perspectives. Yet, the criminal process just doesn't ever lend itself to that. In fact, the cross-examination process just makes it even less likely that it will happen. So we were sort of really suggesting that we develop something completely outside the court process. It would obviously be with the consent of the defendant and the victim, but it was on the basis that if the parties chose that route and agreed to it and went through the process, then prosecution would no longer be open.
Thank you. We probably unfortunately have to call it a day at that because it's 1 o'clock. But thank you very much again, Warren, for making time to come today and for what you've shared, what you've put in front of us to consider. Please join me in thanking again, Warren.